give it to the assistant. So before we begin with the new panel, I would like to kindly ask everyone to make sure that your phones are turned off, so you do not bother the process during the presentations. So if you could kindly turn your phones off and make sure that those phones are turned off before we begin with the session. Thank you so much. We are gathered together here for the last session of today, and the last actually presentations for teaching mobilities, and the last panel discussion which we will have later. For that, the topics fall within the department of the Legal Studies department at IVU within the Faculty of Law. And for that purpose, before we begin with the panel discussions, we would like to invite the Dean of the Faculty of Law, Professor Nicolas Datsev, to have a welcome speech.
Thank you, Arnora. Dear distinguished professors, dear students, dear guests, I would like to, it's my honor, it's my pleasure to welcome you all on the session of the Legal Studies. We did the 3rd International Staff Week. Sorry for my throat, it's a little bit sore, but I could not have missed this opportunity to join this event. Also, I would like to greet you all the members from the Faculty of Law, all the academic staff from the Faculty of Law. I'm very pleased. I'm very pleased that we have speakers that have speakers of high quality, speakers whose quality and caliber is outstanding, I can say. I have read the titles of some of the topics. I also had the opportunity to listen one of the topics previously from Professor Dobrinka from Blagoevgrad. And we really will have I'm sure that we're going to have great presentations, great discussions. You know that nowadays, we're living in difficult times, especially in this period, post-pandemic, having the war in Ukraine, all the global economic crisis, and it's not easy to overcome these obstacles that we have for each country. And the legislation, of course, must undergo some changes, that's for sure, but it's impossible to the legislation to follow the changes in the society, because the society, as you can see, changes so fast. That's why we really need to be inventive, we really need to be creative in having new ideas on how to deal with many of the issues that we have, and we have issues in many fields. I'm sure that our guests, our speakers today will provide us with some great ideas on how to move forward. I would like to express my gratitude to them for taking part in this session, and also I must express my gratitude to the International Relations Office for organizing this event in such a great manner. I wish you to have a great session, and I'm sure that we are going to have really productive and fruitful session. Thank you.
Thank you so much, Professor Datsev. And as soon as we manage to turn on the computer, we will invite Professor Dobrinka Chankova from the University Southwest University, Neofit Rilski from Blagoevgrad, Bulgaria, to present on the topic of restorative justice as a new paradigm of criminal justice. A round of applause.
Great, thanks. So, hello again, distinguished colleagues, dear students. Now I have a very difficult task. First of all, at this very special moment of the day, sleepy afternoon, to keep you awake. I know after this intensive program it's not so easy. And secondly, my task is difficult because I have to present you in 25 minutes, exactly, the work that I have done for almost 25 years, which is more or less mission impossible. But nevertheless, I will do my best to give you an idea about this area of research and teaching that I have the last years. So, it is pretty, restorative justice. It is written as a new paradigm of criminal justice. And I would say that maybe this is correct because it's a pretty innovative idea, especially for our region. But nevertheless, I would like to ask you, what do you think is restorative justice? Is it only a new new way of doing criminal justice, a new paradigm of this type of justice, it is specific territory of criminal justice? Is it a new way of thinking about crime? Is it a new lifestyle or a fashion? Many questions. The answer maybe will follow. But for this, we have to look shortly in the history. I have used several times the word new idea, new approach, new response to crime, but in fact it is not absolutely new. If we look in the history, we will see that there are a lot of traditions of Maoris, native Indians, America, Africans, Aboriginals. So we can see the roots of this idea everywhere in the world. But the new Western wave is coming from Canada, Ontario, when in early 70s, a youth probation officer managed to organize a meeting between victims of vandalism act and the offenders that have done this act. For that time, it has been a really revolutionary idea, meeting between victims and offenders, trying to negotiate the consequences from the crime, trying to replace a punishment with a different form of responsibility, to find a way, and what is the most important, this probation officer has tried and succeeded. He has found a way to keep the relationships and to find a way to live together, all these people to live together in their community. So this idea was really successful and accepted further in many other states, in Canada also, and finally it arrived in Europe as well. But I have to be correct that we can find roots of this idea in New Zealand, Australia. So today, restorative justice is truly on the world map. But why we need restorative justice? This is the basic issue. And there are many answers, and I will give you only some of them, because the functioning criminal justice system in many countries of the world is not functioning in the best way. The criminal justice system has shown a lot of deficiencies. So we need something new. something different. And restorative justice is this alternative way of doing criminal justice or responding to the crime. But one more important point. This is the theory of famous Norwegian criminologist Nils Christie. Maybe some of you have heard about him, about the conflicts as property. Usually we associate the conflicts in our life with something bad, something wrong. But in fact, according to this original approach, the conflicts are something precious. They are value. They belong to their owners. And the state, and especially the justice system, has expropriated, has stolen the conflicts from their proper owner and is providing a decision on a global scale, not only on specific country, that is not always satisfying at least one of the conflicting parties, and in most of the cases, both conflicting parties are dissatisfied from this official decision made by the monopolist of criminal justice, especially the state, because we consider the crime as a conflict as well, the most serious conflict that we experience. That's why Nils Christie decided that the conflicts should be returned to their proper owner, to the conflicting parties, and they should find the best decision for themselves. I feel obliged to give you at least one definition of restorative justice, just for educational reason, because there are many definitions, but the first one and widely accepted was that one of Tony Marshall. And restorative justice is a process whereby all the parties with a stake in particular offense come together to resolve collectively how to deal with the aftermath of the offense and its implications for the future. As you see, quite different thing. So that means that the parties involved in this process or in these processes, because restorative justice is functioning through the variety of processes, are the victims, the victim, let's say the victim, which is, by the way, on the first place. This is very important. Not only the offender is on the focus, is participating, and we are used to see the offender as a center of the acting criminal justice system. But according to restorative justice ideology, on the first place is reserved for the victim, because the victim is in this conflict is the right party. This is that deserves enough attention, more attention that receives nowadays. In this process are also involved the family of each of them, the victim and the offender, plus any members of the society or the community who may be affected. I would like also to point that the role of community, the role of society, we sometimes neglect this role, but according to the restorative justice theory, this is important, not only actor, a factor in our life, and more important. So if you see the diagram of restorative justice, you can see the parties with a stake in offense. Victim, offender, community. The question is, where is the state? Because this is a specific territory. We have the imperium, we have the monopoly of the state to deal with the crime. Right now, I should say that the state is not excluded totally, but it is at the entrance and at the exit of different restorative justice processes. Also, first of all, the legislator should allow some offenses to be considered through restorative justice mechanisms, and later the prosecutor, the court, should decide, after very careful evaluation of all factors, which I will speak, if I have time, a little bit later, and they could decide whether to refer the case to the shortcut of restorative justice models, and after that to approve the result of these processes. In fact, this is a process of negotiation, as you know, between the conflicting parties, with quite interesting results. For example, reparation, restoration, apology, therapy, education, something completely different from typical way of doing criminal justice. Instead of punishment, all these restorative results. That is why it's really a new paradigm of doing justice. I have to be shorter. I know this. But briefly, I will pay attention only on the central elements of the restorative justice doctrine and practices, because this is a great area. This is a whole parallel world of justice. The important is that the victim and the offender are coming together with the help of facilitator. It could be also a mediator, called mediator or coordinator. They resolve the consequences of the crime through mutual agreement, and they are oriented to the future, not only to the past, but to the future. This is also something completely different. So if I could summarize the philosophy of restorative justice, that it provides an extended role of the victims, that it requires offenders to take responsibility for their actions and for the harm they have caused. Restorative justice also gets community involved, and the key word is restoration. Instead of punishment, instead of retribution, restoration. Here is the picture of restorative justice. You will see that the vocabulary is completely different from our typical criminal justice vocabulary. I have more than 100 maybe slides, so I should skip some of them with, yes, please, yes, I know, yes, no, but something I should say extra. The principles of restorative justice are really important. Except participation, involvement, this is also voluntariness, neutrality, impartiality, confidentiality, which is very important for today people because it respects their privacy. It is also very important. Plus equal treatment and many other things. So the objectives I already mentioned: to attend fully the victim's needs on the first place, material, financial, emotional, social. It is not always possible during the court proceedings to attend all these needs, but restorative justice could afford this. Further objective is to prevent reoffending by reintegrating offenders into society. So this is not only this is not isolation. On the opposite, restorative justice offers reintegration, involvement of community, etc. For these tables, I need several hours to explain, because these are really essential. This is really essential comparison between this old paradigm of retributive justice and new paradigm of restorative justice, made by the guru of restorative justice on a global scale, Howard Zehr. But please allow me to skip this. It is time-consuming very much. But this table shows the numerous advantages of restorative justice. Somebody who is interested can go further with this. The key restorative justice values you already know. I have mentioned reintegration, inclusion, mutual respect, empowerment, connectedness, tolerance, definitely different, something different from what we know. I will also skip analysis because I know I should do it, just to say that restorative justice is a concept, doctrine, but it is functioning through the variety of practices. Some of them maybe you have heard. Here it's maybe almost the whole range, yes. And I will only name the most important of them, like victim-offender mediation as a classical restorative justice model. Mediation, definitely you know from civil law, but this is another terrain, a criminal justice terrain. This is how the mediation is done, but for this scheme I also need at least half an hour. The next is family group conferencing, which is a little bit wider format because it includes not only victim and the offender negotiating, but also their families. And this is really productive, especially in the cases of juvenile offenders, for whom restorative justice is a very relevant method as well. Plus community conferencing, plus circles. This terminology maybe is new for you, but that's why I have used some graphics. But every model deserves a special attention. And I have not this idea. I want only to assure the dear colleagues from the law school that this is not only a doctrine, this is not only an idea, this is a regulated area with many instruments which have been adopted by the United Nations, starting with Magna Carta victim rights. Definitely you know this important declaration of the United Nations, and through many resolutions, etc., and the latest one, and the latest and greatest, I would say, the Handbook of Restorative Justice Programs, which I strongly recommend for you to read because it will give really more knowledge for all of you. The Council of Europe is also supporting this idea, this very important organization, through many recommendations and some conventions, etc. The European Union is also supporting this idea through Victims Directive. So this is not only idea, it's a real law, international law. I always receive this question, and so this time I decided to be first. Which are the most common type of offenses referred to restorative justice? It is clear, even from this very brief overview, that restorative justice is not applicable to all offenses. That's true. But some, and I would say a big part of the daily offenses, violent offenses, property offenses, some offenses against personality could be really successfully resolved through restorative justice. Which are the victims that are involved in these processes? Individuals, community, legal entity, even the state could be a victim and participating in restorative justice. The reasons that led to the emergence of restorative justice models also need an extra hour that I do not have. So, first, the new development of restorative justice, I should point out. The criminal justice is the preserved territory for restorative justice, definitely. As I mentioned several times, this is the new way of doing criminal justice. But now we, let's say, the restorativists, the new professional that emerge, are applying nowadays restorative justice in the community, which is also important because the quality of community life is extremely important, in my opinion. And when we have a restorative climate and desire to restore the things, to restore the people involved in this conflict and this offense, to restore the balance in the society, to restore the harmony in the society, this is extremely important. Moreover, we are applying restorative justice in prison settings. Even when somebody is convicted, there is a room for restorative justice because he should reconcile with the victim, with his own family, with his close relative, etc., his community, because they should live further together. So there is a room for restorative justice in the prison as well as in the workplace where we spend a lot of our time. And I dare say that even the boom of restorative justice practices is forthcoming, especially for our regions which are difficult to accept new ideas. Here is, yes, some more information on restorative practices in school. If there are some teachers here or people from pedagogy faculty, they could take act from this. As you are already aware, restorative justice is on the world map, well established. It is practiced widely in Europe, in America, in Asia, in Africa, in Australia, and in New Zealand. Only in Antarctica it's not applicable, if I know well. So this is, yes, the graphic that explains this. What is important, especially for our dear students, is that restorative justice infrastructure. I pay attention on this because this is a new domain, especially for young people that will have their career in the future. But for this, first of all, they should consult the numerous books of restorative justice, the numerous videos. I also have a video, but I'm afraid I have no time for this video.
If you are willing to take like the 5 minutes for questions.
Okay. If we have time. I honestly, I'm in hesitation. There are, 3 minutes.
Oh, okay, yeah.
3 minutes, but it is not stored here because it's too big. But it will be arranged. Just give me 1 minute and to finish it, and it will be arranged. So the next are website, courses, Restorative Justice Week, certificates. Many of you can receive certificates, not only if they come to our university, but also if they go to Canada, the motherland of restorative justice, let's say. If they study online also, it's possible to get more knowledge about this. There are many organizations offering courses on restorative approaches. Please remember this important organization, European Forum of Restorative Justice, which is developing this idea on European scale. The capital of restorative justice in Europe, it is Louvain, Belgium. This is not the headquarters, but it is in the university. We have journals, we have postcards, we have, what is most important, we are exactly on the right place in the right time, because this is the Restorative Justice Week, exactly this week, as you see, every year, and especially this week is Restorative Justice Week, and we are paying due attention to this innovative idea and concept. So, there are many other interesting options. I would like to welcome all of you to restorative justice work and to stimulate you to go further. I believe you will fall in love with this idea. Although, in the conclusion, I would say that restorative justice is not a panacea and not a nirvana. Definitely not. It is not all offenses and not all difficult situations could be successfully solved through it. It is a really modern, very civilized way of doing criminal justice. It is a replacement of our punitive ideology with something which is more contemporary, more humane, more civilized. And of course, there are many ways of doing restorative justice. different ways. They have been trial and errors. Not always it has been successful, but nevertheless, I definitely believe that it is the future. So, just for our distinguished young colleagues, I have prepared a small list of around 100 books, of restorative, dedicated to restorative justice idea. As you see, books enough for further reading. Enough or more? So, plus some website links.
Start it back.
Some website links. And at that moment, I'm yes, I have to thank you for your attention.
I actually do have a question.
Okay, okay.
Well, first of all, do you have the video?
Yes, I have it, but it is well hidden in my bag.
Okay, in the meantime, it's not a problem.
I will try to answer while you are...
Yeah, in the meantime, I'll ask the question. So you mentioned the theory of it, and I think most of us have maybe an idea of maybe how this applies to countries like America, or countries that have like very obvious problems like racism. But could you give us like practical examples for places like Bulgaria? How does that apply in Bulgaria?
Oh, it's a very difficult question to answer.
Hey, you said you have to be quite serious.
Yes, Macedonia, North Macedonia, of course, but short.
No, to us it's Macedonia. It's fine. We don't have anybody from Greece.
Wait a second. Yes,
You can press the-
yes. This idea, yes. Just to answer the question, this idea is coming in the modern format from America. Yes, despite their racist problems with the racism, despite their overcrowded prison system, but they have room also for restorative justice, because this is not for all offenders and all offenses. There is a room and place for restorative justice when the people desire to go to this shortcut, because restorative justice mechanisms are only one instance mechanisms. They finish very fast with less expenses and less emotions, and that's why the people, even in the States, the well-educated, honestly people, informed people, prefer the restorative justice mechanisms. So, about Bulgaria, honestly, we are not avant-garde of the world, but I decided to speak on this subject because I consider myself as a European scholar, and I have spent many years in these organizations, developing these documents, etc., etc. We have it in the legislation only with one regulation in the mediation law from year 2004, that we can refer many cases to restorative justice system, but in practice we have not very much experience, only some pilot projects, only some far-seeing judges and prosecutors are using restorative justice model at that moment. So we are still at the stage of convincing the audience for using restorative justice model and their benefits.
So then thank you for this presentation. I hope that inspires the young lawyers that are present here today to apply that to their future careers.
I do believe this is the case, and please allow to give me, it's a 3 minutes video, and I believe it will enjoy.
Tell you face to face how much that crime has affected you and show them the harm they have caused. Now imagine being a criminal and hearing firsthand from the victim the pain and suffering you have caused them. How would this make you feel? Restorative justice makes this happen, and really does have the power to change people's lives. By facilitating contact between the victim and the offender, restorative justice gives victims a chance to explain to offenders the real impact of their crime, to get answers to their questions and an apology. It holds offenders to account for what they have done, helps them understand the real impact of their crime, take responsibility, and make amends. Many victims of crime feel that they are left out of the criminal justice process better altogether. Restorative justice gives victims a voice and the opportunity to play a part in helping prevent others from becoming a victim. Research funded by the Ministry of Justice has found that 85% of victims who take part are satisfied with the process, and the frequency of reoffending reduces by 14%. But it's not until you hear directly from people who have participated in the process that you really understand the benefits.
The reason I wanted to take part was because I wanted to put across this person who really made me very angry, put me through a lot of trouble. I wanted him to understand what it felt like. I wanted to make him understand the impact that it could have on somebody else, and make him think about it and realise that if it happened to him, how would he feel? I don't feel like a victim anymore. I came out of that room not feeling like a victim, and that's what it did for me.
By making criminals face the true impact of their crimes, restorative justice helps reduce reoffending. This means that there is less crime and fewer resources needed to prevent and manage that crime. The benefits of a lower crime rate within a community are numerous. With many criminals reoffending on a regular basis, restorative justice offers a proven way to support communities whilst helping offenders turn their lives around.
I've never felt sorry kind for what I've done in the past, but I've never put a face to my crimes, so it never kicked in. But the last time I wanted to change my life. I had to change my life, and you have to start from bottom up. So I wanted to meet him to apologise. He got some guilt out of me. He gave me something to work on from then. I've been trying ever since, to be honest with you.
Restorative justice isn't something that just happens automatically. Meeting the perpetrator of a crime committed against you is a serious thing, and a lot of work and planning goes into making sure that the meeting is safe and effective. A restorative justice meeting, often called a conference, includes support for both the victim and offender. A trained facilitator guides the participants in a dialogue, ensuring that each participant has a voice in the proceedings. There are 3 basic requirements that must be met before a conference can take place. The offender must accept responsibility for the crime. Both the victim and the offender must be willing to participate. Both the victim and the offender must consider it safe to be involved in the process. Find out if restorative justice is happening in your local area and get involved.
Thank you so much. Now we'll take more questions. Yeah.
Yes, of course, definitely. I'm available.
Yes, thank you for this impressive lecture. I'm wondering whether, for example, North Macedonia, Bulgaria, also the Balkan context is as such that we are small communities and people know each other more frequently than in, let's say, United States of America. Do you think that small communities are good precondition for restorative justice, or they create more obstacles?
Yes, I do think so. I think restorative justice is especially applicable in community, in the communities and community-oriented, let's say, states, because the role of community is really important, in my opinion, and definitely it could help for better common life. So I think North Macedonia and Bulgaria are the countries that are excellent places for restorative justice. It's a question of somebody who should introduce it. Maybe you, maybe some colleagues.
All right. So, Professor, thank you for your presentation. It was very good topic. So I would have a question, because you mentioned that those kind of restorative justice, it doesn't apply on all types of offenses. What do you think? For, let's say, that crimes that are more obvious that are happening in the world, like organizing terrorism and those stuff. Do you think that this kind of justice will be ideal for those kind of offenses, or this is your opinion on
No, not only my opinion. This is well-established practice that it's, as I mentioned, not all offenses are appropriate for dealing with restorative justice mechanism. Organized crime, drugs, and some crimes against the state are not really acceptable. Good idea to apply restorative justice. Usually the legislator decide which type of offenses in every country could be referred to restorative justice, but as a rule, this type of offense that you have and some other are initially excluded from restorative justice. But there is enough room for other numerous offenses in our life. Yes, please.
Okay, so Professor Dobrica, congratulations on your splendid presentation. Now, in our case in Macedonia, in our legal system, we already adopted some restorative justice mechanisms, such as in criminal procedure we have settlements, we have also in tort law we have settlements. Instead of litigation, we have settlement, which parties can come together and resolve their dispute and just then go to court and draft a settlement. Also, we adopted a couple of years ago mediation as form
yes.
Alternative dispute resolution as restorative, when parties get together and they solve their issue in front of mediation, do not enter into the court channels. But again, the parties, in this case, plaintiff and defender or perpetrator and
victim,
the victim, again, they trust more to the court system and they go through that channels. Also in criminal procedure, even though we have a lot of, how to say it, the sanctions are getting soft, we have alternative measures and stuff, but yet again, the crime rates keep going higher. And I'm not saying about those criminal offenses which are a bit more, let's say,
suitable.
Yeah, suitable. Again, even those criminal offenses are pretty, how to say, pretty in more meant person-to-person level, not person-to-state or organized crimes. Again, the crime rate is still continuing to going up and higher. So in our case, I think the restorative justice up till now it doesn't have the expected effect. So I don't know, what is your opinion in this? Do you think that maybe in societies like us, as in Macedonia or Western Balkans, we are not yet ready to soften up and to go with this?
Shortly, because I have stolen part of the time of the distinguished colleague. Yes, you touch a very important point maybe, but I would like to assure you that restorative justice works well in so many reasons, so many regions, and we are not so unique, both countries, North Macedonia and Bulgaria. We are simply more reluctant to the novelties. If the advantages of restorative justice are well explained, it will be accepted in the society. And as I mentioned, it helps for reducing reoffending. On the opposite, because we do not have at that moment restorative justice, that's because the crime rate is higher and higher. But it is enough, there is enough evidence that restorative justice is work for reducing crime or for preventing crime, etc. So simply we have to start with these models and we see the results. But if it is a well-established practice, maybe it is really something good.
Thank you so much.
I think I have to leave the place for the colleague. Thank you very much for your attention.
Thank you so much to Professor Čankova. You will be able to ask her more questions and have more in-depth discussions during the coffee break.
Definitely, I'm available.
Or establish contacts through the email provided. Over here. Okay. So next, our final presenter for all of these sessions and for our International Staff Week, so we could say we have left, like, you know, the best for last, is Professor Milan Jazbec, coming to us from Nova Univerza in Slovenia on the topic of diplomatic and consular law, selected aspects and dimensions.
Well, thanks for this welcoming encouragement.
Yeah, of course. You have these two here. Which one should I open first? The Vienna or the first?
The Vienna.
No, the second. No, okay. Make it first.
Click here, no?
Yeah. And here.
Okay. So, thank you.
Thank you so much.
So, hello to everybody. Pleased to be here again at International Balkan University. Not for the first time, but for the first time at the International Staff Week, what is official title. So, hello to everybody. Respected colleague, Dean of the faculty, the former Dean, Zonia Adnora, my colleague Chankova, so all of you. So, since the time is limited, I should go straight to the
Like the coffee break can wait.
yeah, okay, to the coffee break. Okay, yeah. So and this is somewhere in future, né? Yeah. But I would have first my principle of this lecture. I like to follow an Arabic proverb saying that goes like that, like this: do it fast, speak a little, and tell a lot. Sometimes it is possible, sometimes it's not. And for this lesson, which is the last one today in this part of that week, the conference, I have a proposal that goes from the introduction remark of Professor Chankova. So I propose those who slept during her lecture be awake now, and the other way around, okay? So that we are both on a nice consensus basis. I'm joking, but to be relaxed. So. My topic is the philosophy of the preamble of Vienna Convention on Diplomatic Relations. So don't blame me for this interesting and unusual title. I was told, I was given the topic, selected topics from the diplomatic consular work, law, and I was given this topic, and then I have chosen this one. So. Let me say for the beginning that, as you all know, I guess you know, I'm sure you know, in front of the professor I say I'm sure you know all this, you know that the Vienna Convention on Diplomatic Relations, adopted or done at its official language in 1961 in Vienna, and the Vienna Convention on Consular Relations, done 2 years later, and 3 years later entered into force. These two conventions, they form the basic foundation of the diplomatic and consular law. They codify diplomatic and consular law, and since, as you can see from this, they both have around 180 ratifications. So these two conventions have the biggest number of ratifications within the area of diplomatic and consular law. This is almost all states have ratified them. So this is a very interesting fact that tells about the strength, the power of these two conventions, also about their acceptance in practice and respecting them. I will speak today only about the diplomatic relation or the preamble of the Vienna Convention on Diplomatic Relations, but my presentation and these findings, they could be easily also implemented to the preamble of the Vienna Convention on Consular Relations. So let me also add that there is a huge number, nobody knows, I guess, of interpretations, articles, books that were written about both conventions, about their practical, empirical interpretation, consequences, and so on and so on. But most of these writings focus on interpretation and reinterpretation of both conventions, of various articles, and they more or less stop there. During my lectures, and studying both conventions, I got somehow the idea, I don't know when, why, and then and how, that there is more in both conventions than just pure interpretation. What does it in practice? Diplomatic functions, consular functions, diplomatic and consular immunity, privileges, and so on. There is more than just this, let's say, queuing of issues, topics, and understanding them, and applying them in diplomatic and consular work. So I named this view approach, or philosophy of the preamble, because I think there is much more in the preamble to be understood, that we can grasp from it, absorb from it, and understand from various points of view, not only this strict, let's say, practical, applicable point of view. as you see, I'm now already going into the meaning of the both preambles. I will touch upon heavily on the structure of the preamble, because I think the structure as such was not just chosen like that, or by some routine order of appearance of those people who were composing it. Both preambles have strong messages, characteristics, and so on. So a few words about the relation between the Vienna Convention of Diplomatic Relations and Vienna Convention of Consular Relations. Basically, they are complementary. So they complement each other, and they both form the complexity, how should I say, of the diplomatic and consular law. They are also interdependent. There is a strong interdependence between them. They are on equal formal footing. So we cannot say that consular convention is subordinated to the diplomatic, or the diplomatic is a dominating one. There is equal footing, interdependence, complementarity, but of course it is obvious when we read them and study them that the Vienna Convention on Consular Relations derives from the Vienna Convention on Diplomatic Relations. But this is just, let's say, a sequence, order of substantial appearance, nothing more. So Vienna Convention of Diplomatic Relations preamble. Main characteristics of the preamble. I will discuss this in details when I will go through all these 5 clauses. There is a lot of tradition there. Of course, this is normal because diplomacy is all about tradition. Diplomacy in the first origins started 3,500 years before our age. So it means around more than 5,000 years. For the last 5,000 years and something, we can speak about diplomacy evolving from the first origins till this, what we have today, and what is codified by the both conventions. So it is a huge tradition in that profession that is also, how shall I say, cemented by the legal approach. There is a strong continuity, but of course that the diplomatic practice could have stand throughout that period. It also had to be, and still is, open, flexible. It shows respect, mutual consent, ethics. So when you deal with the diplomatic business and stemming from the diplomatic and consular law, there you should have some kind of mutual consent. For example, diplomatic relations between two countries are established upon the mutual consent of both countries, etc., etc. So nothing could be done by one side only. So, and this is already felt, and we can see this in the preamble. Preamble is broad, clear, very, very firm. It has a very firm legal background, but it also vibrates emotions, ethics, and some, I should say, human touch, although it is basically a dry legal document. And because of this variety of characteristics of the preamble, we can say that the committee that has prepared the convention, they must have had a lot of knowledge, expertise, and they for sure have not only been lawyers and only legal experts. We can also say that from the preamble there is a pure concept of diplomacy radiating out of it, vibrating. So it is a strive for peace and security and friendship among countries and functionality. So these are the basic premises of diplomacy as a profession. It is not only that these are basic parameters of a legal document as such. Structure of the preamble is very interesting. So it has opening and closing sentence, and altogether it has then 5 clauses. And within these 5 clauses we have again the opening clause, the closing clause, and 3 that are the main body. So this is not just playing with the structure and trying to do something out of it that you will have something to study and to learn and to know at the exam, but it is, to my mind, it is a well thought over structure that the messages of the preamble would be clearer, stronger, more obvious, and with this the basic foundation for the understanding of the whole convention would be better, stronger, and would survive, let's say, throughout the period of time. But by the way, there is about 60 years have already passed since the adoptions of both conventions. They are still there. There hasn't been any significant effort to change them, to modify them. Some of the articles or parts of the articles are already outdated, but we can see that both conventions are still valid, countries follow them, diplomats implement them. So this is a kind of fascinating legal documents that have they span across not only such a long time, 6 decades, but also they survive these tremendous changes in the international community, its structure, and so on. So preamble, opening and closing sentence. Opening sentence. The states parties to the present convention. That's it. No? So this, what is the meaning and the function of this opening sentence? As we see here, it opens the Vienna Convention of Diplomatic Relations, normally, logically, but it also defines the participating subject. They are states that are parties to that convention. Nowadays, as I said, I think that it has 192 or something ratifications. Basically, we can say, with a little bit of generalization, that all sovereign states that are members of the United Nations are parties to this convention. It was not the case immediately at the beginning. At the beginning, as we can, as I put it in the first slide, there was. I don't have the number here, but okay. So when both conventions entered into force, only the minimum required number of states were parties of this convention. Now, as we can see, practically all the sovereign states are parties to these conventions. They are participating subjects. They implement the preamble, they implement the convention, and they use it in the daily diplomatic and legal practice. Then, second, this opening sentence also forwards us to the substance and inaugurates the preamble. So when we go from the first, this opening sentence, we come to the basic central meaning and structure of the preamble. And then the closing sentence, after the preamble is done or read or understood and so on, says, have agreed as follows. And then it means that the closing sentence, of course, closes the preamble. It opens or inaugurates the text body of the Vienna Convention as such. So from then on, from the closing sentence, we move to the body of the convention. And with this closing sentence wraps up the preamble as an independent text. We can read the preamble, the 5 clauses, as an independent political manifest. One can also say, with a little bit of exaggeration, not a bit, not a lot, that preamble of the convention is an independent legal, political, ethical document, and if we read the preamble and nothing more, basically we know everything what is important for diplomacy and for its legal background. Of course, it is not just like that, but basically we can say this. When we know, when we go through the convention and when we know the convention, then we can see, okay, this, practically everything is within the preamble. So I said preamble has 5 clauses, preamble of the Vienna Convention on Diplomatic Relations, 5 clauses, and within these 5 clauses we can also say the first one is the opening and the 5th one is the closing. So I hope that you already know the Vienna Convention or studied it. If yes, it is easier for you to follow. It is. If not, it's not that easy. But maybe this will introduce you to the document and intrigue you to listen a little bit more than when you have this on your course agenda. So the first clause number 1, opening. So we see from before. States parties to the present convention, what they do? What do they do? Recalling that peoples of all nations from ancient times have recognized the status of diplomatic agents. So what does this mean? Here we have the origin of diplomacy. It means tradition from ancient times. So diplomacy stems from ancient times. Peoples of all nations from ancient times on have what? Did what? Have done what? Recognized or recognizing the status of diplomatic agent. It means immunity. So if you want to do diplomacy, the messenger have to have immunity. Don't kill the messenger. You know this phrase. Ne? There is also an, how should I say, interesting saying, who was the first diplomat? The first diplomat was a person who came back from the negotiations with the neighboring tribe alive, was not eaten. Because they understood that the messenger has to come back, not only to go there. Ne? So this is diplomacy. You send the messenger, you receive the messenger. You see, this everything is within that 2 lines of the opening sentence. So diplomacy, origins of diplomacy is recognizing the status of diplomatic agent, then a tradition and the immunity. Of course, in practice, we don't know when the time arrived that all messengers have had the diplomatic immunity and that this immunity was not breached. It happens. It happens. For example, a kind of a, how should I say, illustration. It for sure have had happened. I'm sure if one would study diplomatic instruments and reports, situation like this, that the diplomatic agent or envoy was received, respected, he did or she did the job and left. But of course, if something happened on the way, on the street, on the way, some accident and the envoy was killed, well, yeah. So this does not mean that overnight immunity as such entered into force. It was a process. Yeah? Next, the clause number 2, saying, having in mind the purposes and principles of the Charter of the United Nations concerning the sovereign equality of states, the maintenance of international peace and security, and the promotion of friendly relations among nations. So basically, this is essence of diplomacy. You see, né? So the sovereign equality of states, maintenance of peace and security, and promotion of friendship. So this is the basic what diplomacy is all about. If you compare this second clause with the 5 diplomatic functions, you will see this is the base. This is everything what we have to know about diplomacy. At the same time, it shows also the principles of diplomatic job and also ethics. What is more ethical than promotion of friendly relations among nations? Common good, common good. Eh? This is the best parameter for achieving peace, stable peace, and then live in a secure environment. Of course, one could say, okay, these are some idealistic interpretations and so on. Yes, of course. But if we look at the international community, we can see the growing trend of respecting this. My predecessor, Professor Chanko, she spoke about trends. We can see here trend. I'm sure that if we will analyze carefully, empirically, how this was implemented throughout these 6 decades, 60 years, I'm sure we would see the upgoing trend. So, essence of diplomacy and ethics about all, because you know about diplomacy they say that the diplomats manipulate, diplomats lie, or whatever. There is no room for ethics. Indeed, it is. But of course, it is not automatically, not by itself. And of course, diplomats depend on politicians. Diplomats do this, what politicians decide. So sometimes they say for a diplomat ambassador, he's changing his mind each day, his approach to the international relations and our agenda is different. If it is that case, sometimes happens, it is not because the diplomat will just be changing his or her mind. It is because his or her government is changing decisions and views. That's the point, that's the relation. So diplomats have a lot of maneuver space to work, to perform their duties, but of course their outer frame is the decision of their governments. The first, it was the British envoy at the time. At the time, the term ambassador was not in use, not yet. I think in early 16th century, in Istanbul or in Byzantium, the British one envoy who said, "Diplomat is an honest man who is lying in favor of his own country." So the anecdote says that when this was heard in London, he was immediately recalled from the duty. He tried to get out of this trap, saying, well, I was just joking, but this explanation didn't help. He had to leave the receiving state. Clause number 3. Believing that an international convention on diplomatic intercourse, privileges and immunities would contribute to the development of friendly relations among nations, irrespective of their differing constitutional and social systems. So, goodwill. States that are parties to that agreement, they believed and they still believe that irrespective of differences among them, political systems, social approach, and so on, that irrespective of these differences, there could be the development of friendly relations among them, and with ratifying this convention, this preamble, this clause, they show their willingness to accept and to respect differences, political, constitutional, religious, ethnic, etc., etc. This is also very encouraging. It shows goodwill, it shows good intentions, acceptance of differences. What's the mantra of nowadays? Mantra of globalization. We are all different. We are all equal, but we are all different. And accepting these differences and benefiting from them. That's the point. Here we are all different, and this is the treasure. This is the treasure. This is the pleasure. This is the way how it should be, and all this. Focuses to common goals. To common goals, maintenance of international, developing friendly relations among states. And at the same time, this clause number 3 gives a background for the adoption of the Vienna Convention of Diplomatic Relations. So it would be this convention that would help achieve all this. So it shows also the function of the document. This document, Vienna Convention of Diplomatic Relations, is in function of achieving these goals. Okay. Next, clause number 4, realizing that the purpose of such privileges and immunities is not to benefit individuals, but to ensure the efficient performance of the functions of diplomatic missions as representing states. So, when this convention was adopted, and it forwarded in diplomatic immunity to diplomats, there was a point, the point was made out with the realization that the purpose of these privileges is not that a single diplomat will benefit. It will have an easy access to everything. It will have, I don't know, cheaper goods, and all these things. All these things, they are guaranteed for that reason that the diplomats are in the position to easier perform their duties, present their states. So this is a functionality of the convention, and of the diplomatic missions which represent states. This is also evolution in understanding the functionality of diplomacy. Diplomacy, well, started for the major part of its existence, diplomats were representing heads of states, the president, pasha, sultan, queen, king, whoever. But after both conventions entered into force, especially diplomatic convention, diplomatic one, diplomats and diplomatic missions are representing their states. So this is the modern understanding of diplomacy. Of course, they represent also heads of states, because it is the head of state who signed the letters of credentials, letters of credence. But diplomats present their states. And what is also important with the diplomatic immunity, immunity is absolute. Everything what diplomats do in their job on behalf of their states, for this they have absolute immunity. So it means after 4 years, 5 years, 10 years, 2 months, when diplomats finish their mission, they never can be processed for this, what they do, what they did during their term in the receiving state or the receiving authority, if they did so on the instruction from their government. So this is very important. Clause number 5, the closing clause, affirming that the rules of customary international law should continue to govern questions not expressly regulated by the provision of the present convention. So, as we see, this final closing clause, it wraps up the preamble, the spirit, the message of the and the concept of the preamble. But what is the most important? The most important is that there is a trust invested in the power of customary law. So simply saying, everything what comes on the diplomatic agenda, everything what appears, whatever, whatsoever, and is not regulated by this convention, should be regulated by the customary international law, although we don't know what can appear and how it will be regulated. So this is the power of law, this is the power of international customary law, and we who are not lawyers, legal experts, we can envy you, lawyers, that you have such a power deriving from trust, you know? Just from trust, nothing else. So now I will finish. If I have a lot of time, I will speak slowly, otherwise I will continue with the fast.
7 minutes.
Okay, yeah. So let me now wrap up the main messages and the wording of the preamble, and with this also diplomacy. You see, diplomacy, I said a few times, the pure essence of diplomacy, the meaning of diplomacy, this is what diplomacy is all about. So careful choosing of words and constant sending messages. This is what diplomacy is all about. Some people say that the easiest job in each country is the foreign minister. You have 5 to 7 to 10 messages and you're repeating them all the time at each occasion. And this is basically true. But of course, it's also about persuasion. It's also about implementing interests of the sending country, of your country, in the receiving state. It's also maintaining dialogue on the spot. So permanent dialogue and permanent personal contact on the spot. So this all is diplomacy, and this everything derives from the preamble, its 5 clauses. So let me repeat, so very briefly to sum up, the preamble and its codes. The states parties to the present convention recall, have in mind, believe, realize, and affirm, and then have agreed as follows: blah 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 blah. All the articles of the convention, all the 53 articles of them. So. And then comes, as I said, the full text of the convention. So basically, this is diplomacy. Enjoy and study it. This goes for the students, but also for us. And I hope that you will enjoy it. Maybe also for this reason that they say that there are numerous definitions of diplomacy. Each theoretician has her own definition, and the charm of these definitions is that they don't contradict each other. They all complement each other. So this is the charm. But this is the charm for us who discuss and research this. I'm not so sure that this makes also a charming effect on students, because basically we have to learn a lot. But that's life. So thank you.
Does anyone have any questions? Yes, Anthony?
Sorry for my voice.
Wait, is it okay if I give you the mic?
So you are the new dean? That's good. That's good.
Professor Milan, thank you for your great presentation. It was a fantastic presentation. And my question was regarding nowadays, Professor. So since we are facing many challenges, especially the war of Russia and Ukraine, how much effective is diplomacy nowadays in those dark times that we are living?
That's a good question, thank you. You would remember when the war broke out. First, nobody believed, and then there was a shock, and then there were comments, this is the disaster of diplomacy. This is the total failure of diplomacy because it was not possible to prevent the war. Well, I don't agree with those interpretations. I also said this in a few public statements when I had some interviews and these things. Diplomacy, as I mentioned, diplomacy is not politics, but of course is very closely depending on politics. So if the government decides like this, diplomats have to do this. If the government decides like this, diplomats have to follow this. So if the politicians don't, how should I say, allow a frame for diplomacy to do its job, then diplomats can do nothing. And this is a kind of a frustration. This is a kind of a frustration. But you know, at the same time, I don't know how many wars were prevented by diplomatic actions, and that we would know this. Huh? Because if diplomats manage to prevent a conflict, prevent a war, nobody knows about this. Huh? And if we read then later on this in memoirs, we can believe or not. But of course, wars happen all the time, unfortunately. I would say that the trend is, the number of wars is going down. I would dare to say this, so by generally speaking. But of course, you know, what is more typical for diplomacy is that diplomats have to have contacts with everybody. When you are an ambassador in the receiving state, of course it's easy to have the contacts with the coalition, the government, the top representatives of the states, because this is your duty. It goes by itself. But of course, diplomats have to have also contacts with the opposition parties, parties out of the parliament, and so on. Because diplomats are there, sent there to maintain relations and to be ready to solve problems when they appear. And problems can appear for various reasons. And from some paradoxical point of view, contacts that you have as a diplomat with those troublemakers in a certain country are even more important than with the legal decision makers, because you will need to have contacts with them to solve problems. So this is diplomacy, and diplomacy has to maintain contacts with both sides, with both conflicting sides all the time, all the time. That's the point. And in this case, diplomacy is then useful. You know, in this, the case of war in Ukraine, you know, there are discussions all the time about negotiations and so on. It means, if there are discussions about necessity of negotiations and so on, it means that diplomats are in contact. They try to do this. And when the political circumstances will be mature, there will be negotiations. That's it. So diplomats can do a lot, can achieve a lot. But of course, the outer frontier is the political preparedness. No? Yes. Yeah.
Thank you very much for this inspirational speech. I used to work myself for a couple of years in diplomatic services. So I remember one thing, that there are few issues in diplomatic services, and they end on all. For example, cholesterol and protocol. So I don't want to take much of the time. I just wanted to ask, what is your opinion regarding the professionalization of diplomatic services vis-a-vis, for example, sending some politicians in ambassador positions?
Well, yeah, thank you. Well, if you ask any diplomat, the answer is the same: professional diplomacy. This is all what is about. It is about. But of course, I mean, practices differ from country to country. American diplomacy is known by there is a lot of politicians in the American diplomacy, but usually the sentence is not finished on ambassadors' positions, not on the positions of career diplomats. You know, so it's easier for a political appointee as an ambassador if there is a huge team of career diplomats. That's the point. Ne? I don't know if it will be possible to achieve a situation that nobody apart career diplomats will be diplomats. Maybe it's also not necessary. But you know, it is important that those who land in diplomacy with the parachute from politics, whatever, that they at least have a basic understanding of this, and that they are aware of career diplomats and that they use them. This is the point. And of course, again, this could be a kind of a frustration for career diplomats, because it's some cases easier to be ambassador if you are a political friend or friend of the minister or whomever, then climbing up the diplomatic ladder. But this is the choice, matter of choice, and of course, I'm sure that everybody who have chosen diplomacy as a profession would not regret this. So, but of course, it is a profession, and it should be treated like this. And you can imagine that I'm sure that American diplomats, ambassadors, those, I'm speaking now about them, but there are also others in other diplomacies, political ambassadors, they use career diplomats a lot, because otherwise there are gaffes, anecdotes, problems, etc. There is one book I would recommend to you to read. Only one, because you have received hundreds of books from my predecessor. This is only one, so 101 book. John Ure, U-R-E, John Ure. He is retired British ambassador. He published a book, True Brits. Book was published in 92 or 93. It is a collection of diplomatic anecdotes from Ivan the Great, the Terrible, till early 90s. There is a lot of anecdotes, almost 200 pages, from real life. He collected those and selected those anecdotes from memoirs and so on. And when you read that anecdotes, you can learn a lot about diplomacy. The one anecdote referring to this, your question, the American ambassador in Italy in the first part of the 50s, it was a lady of one famous politician. She was also media mogul, and she was then, awarded with this ambassador's posting. And when she came to Rome, of course, invitations were pouring in for all possible things. And she at the beginning, she once left to a dinner, and she asked her protocol officer. Each American embassy has at least one protocol officer for such occasion. She asked him, well, when can I leave from that dinner? And the answer was, immediately when the guest of honor leaves. Okay, thank you. She didn't ask more, only this. And then she went for a dinner, and dinner started, I don't know, at 9, blah, 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 and somewhere at 11 o'clock she was bored and she wanted to leave, and she asked her, the guy sitting on her right, was whispering, pardon me, when can I leave this boring dinner? And the reply was, immediately when the guest of honor leaves. Okay? And after 10 minutes, she was looking around, nobody left, and then she asked him, pardon me, who is the guest of honor? You, was the answer. So, it's enough, huh?
Thank you so much to Professor Yazbek, and thank you to everyone who asked very insightful questions in both the panel for political sciences and the panel for legal studies. We will continue in 10 minutes with the panel discussion. Right now we will have a coffee break. Thank you. That means you don't have to break the coffee cup for the coffee break.